Hi, everyone. Kathleen Sullivan, Fine Gauge Strategy from outside of Boston. Nice to see all of the friendly faces. I'm going to be covering contracting tips for independent consultants. Overall, the reason that this is a topic that interests me is that I feel that a good contract protects and promotes your interests as a consultant and is a foundation for a mutually beneficial relationship with your clients. Want to note that some of this information is not going to be relevant to you if you work principally for a government agency or a university or some other highly regulated, very bureaucratic organization in which the contract provisions are pretty much immutable. You may be able to deal with these organizations. I would defer to Matt and Susan and other experts to correct me. Matt says maybe. If I'm wrong, my clients are exclusively nonprofits and foundations, and I have found that even the biggest of international foundations will in fact deal if you address them respectfully and thoughtfully from a position of knowledge. Disclaimer that I need to give, I am a lawyer by background. I continue to have licenses in active licenses in 3 states. Maybe one of those states is yours, but what I am about to say right now is not legal advice. So just going to hit on some top points in the handout that you all should have received, and then we'll leave plenty of opportunity for questions and answers. The first thing that I always say in conversations about of this sort is get professional advice on your contracts. As I said, I am a lawyer by background. I'm actually not admitted to the practice in the state where you are seeing me now. I'm admitted in 3 other places. And even if I were admitted in Massachusetts, the likelihood of my being able to write a terrific contract is, kind of minimal. What I do myself is I write my own contract provisions, and then I provide them to my own small business lawyer who reviews them for me. And he and I have a back and forth about what I'm attempting to achieve. You can start at a different point with your lawyer if you're not very practiced in legal provisions or legal speak. In most parts of the country, you could have a contract reviewed or drafted for you for a few $1,000s maximum. Anytime you set up a meeting with a lawyer, they should upfront tell you what their consultation fee is and what their billing rate is. If they don't, then you want to find yourself another lawyer. And on the sheet, I have at the bottom, I believe, some tips about where you can find yourself a small business lawyer. When you start out in creating a contract, it's very important for you to know what the most important provisions are for you. For some of us, it is timely completion of the project. For others of us, it is being paid a certain percentage of it up front. Good idea if you are beginning a contract or renewing a contract to really sit down and think very carefully about which business issues are most important to you. Good to have an accountability partner for doing that. Sometimes I use my daughter, who's very smart and thoughtful, and also has heard me complain as a kind of accountability conversational partner about this. I also have a couple of small networking groups. And so start out knowing what it is that you want. And that's a great list to bring to a lawyer, because a lawyer is going to want to be starting from knowing what your specific most important interests are. In terms of one other issue with respect to substance, think of the common things that can go wrong and include those affirmatively in the contract. So, for example, I had a situation early on in my consulting practice where it was unclear whether the assignment that I was getting. The board was very interested in the assignment, but I was reportable to the executive director. And when the executive director dragged their feet on completion of the assignment, it got a little dicey. And in retrospect, my contract was not as clear about who I was reportable to and when. That's the last time that I've made that mistake. You will hear, if you start to have conversations with your friends who provide professional services, and it doesn't just have to be evaluation consultants, it can be people like, your tax accountant or other small business people who you relate to on a day-by-day basis. Just keep your ears open for essentially scary client stories, and be thinking about those, and take a look at your contract and see if, in fact, your contract would cover you if something of that sort were to happen to you. Last thing that I will say before we go to Q&A, and this is not a tip that I got from a lawyer, and it's not a tip I thought up myself. I got this from a non-lawyer, but speaking as a lawyer, it's a very good tip, which is don't fuss with the client's lawyers. What often happens, particularly with bigger organizations, is that you negotiate the general terms of your engagement with the commissioners of the evaluation. Maybe that's program people, maybe that's their measurement and learning people, and then they hand you over to the lawyers for negotiation of the contract. If you take a look at that contract and it has provisions in it that are objectionable or problematic for you, intellectual property is almost always one for me. And it doesn't seem like the lawyers who you're dealing with are going to give on that issue or deal on it. Don't fuss with them. Go to the commissioner of the evaluation and make it their problem. If in fact they want you enough, then they will exercise whatever stroke they have, and they will go to the legal team and help you to navigate your way through it. And I think that's all I'm going to say in terms of the top tips, and happy to open it up for people's questions. And also, if you have your own advice about contracting, how you've worked on contracts and or with lawyers, I would love to hear them.
Kathleen, under what circumstances would you start work on a project when the contract's not finalized?
So my formal answer is never. And my informal answer is I do it all the time.
Yeah, I'm glad to hear you say that, because I do too. And I say the same thing. I tell everybody the same advice. Don't do it. But we're currently working on several contracts, and we're actually getting paid, and they're still working through the contract process. They're paying us, and they haven't signed the contract.
That is impressive. I've never had that happen, but I have worked with for a major foundation funder for 6 weeks before the contract was signed. Yeah, no, it's a good idea to have to know that you are going to either have that contract inked or know that it is going to be inked. I mean, there's a lot of organizations, and I'm even finding this now with nonprofit organizations, not even the hugest ones, where their back office folks, their finance folks, are big sticklers for getting your signature on a contract before they want any work done, which I think would be good.
Can you talk a little bit more about the intellectual property provisions? Because I feel like I've seen kind of a differentiation between, like say the report and the tools. What are your provisions?
Yeah, absolutely. So I developed in coordination. I'm trying to remember exactly how it happened, but I developed, and then I had my lawyer review my intellectual property provision. And what it says is that if I develop a tool for a client, not a report, reports are different, and I'll get to that in a second. But if I devise a mechanism, a tool, an illustration, a, blah-de-blah table for a client, I will give the client a perpetual license to use, which means that the client's board, the client's subsidiaries, the client's interns, students, brother-in-law, et cetera, can use this tool that I developed for them forever, as long as they credit my firm, you know, someplace as owning the tool. They can do whatever they want with it. They can't sell it. They can't sell it, but any use that they want to have of it, they can use it for. I continue to own it. Now, why do I do that? And the way that I explain this to clients is the client benefits because I don't have to start from scratch. Every time I get a new client engagement, I don't have to start from some zero developing a tool because I own the tools in the toolbox, the tools that I use, and that therefore I don't spend X number of hours developing a tool. Reports are a different matter because with a report, unless you've got some, you know, whiz bang, interesting technological, you know, methodology for delivering your reports, that might be a little bit different. That's not a situation I have because my reports are boring. They're on word processor. That's a different situation. But if I am doing, you know, theories of change, spreadsheets, decisional tools is a big thing that I use with clients. I do, in fact, attempt to get that licensing provision. Now, I will say that your client's default provision, which nobody in your client's office, other than the lawyers, have ever read, says that they own your intellectual property starting from the finger painting that you did in preschool, right? That's what it says. And I have had real luck pushing back on that by saying to the client, you're never going to use this dang tool again, right? I'm going to use it for the next client, the next client, the next client. There's not any reason why you should use it, why you should own it. Because I take that ownership thing seriously. Is that helpful?
Yeah, absolutely. Thank you.